right. Well, welcome everyone. We have a special guest today, one of our favorite special guests, even if you have to delve into the legal world. But we're very pleased to have Gov Hutchinson, who's been with CAR since 1985. I know there's some CAR VIPs on the call as well. Know Gov very well for all these years. He runs the hotline for CAR. And he's kind of our go-to guru, our legal beagle, and one of the things that I want to share that many of you may not know is this past, well, since actually March, the end of March, when the pandemic hit, CAA rallied the troops and pulled in the brokers that met monthly on a Friday morning for many weeks into the summer, I think into September, every week. Gov gave us the new form that had come out, and then the next week it was the revised form, same form, and then so it was like just a roller coaster those first few months. But Gov and CAR helped navigate the path for us so that we could still be essential and work and have one of our best banner years. But there were laws that came into place. So without further ado, let's welcome back our friend Gov Hutchinson. You're on, Gov.
All right, thanks, Vicki. Good to be here virtually. Wish it was in person. I just want to update you on all the laws and forms that have recently come out that you need to know about. It never stops. I sort of want to commend all realtors, all you guys who've been able to adjust and be flexible since last March as things keep changing. As Vicki said, you're still able to do your job and do it better than ever, but it's just hard. And all I can say is you got to continue to be flexible the next few months. I think we all see the light at the end of the tunnel, but we're not there yet. So we just got to continue to follow the rules and adopt. Things are going to open up gradually, legally also, but it's probably going to be a gradual thing, and it may vary depending on your locality. So you just have to really pay attention to what's going on, as you have been doing for the last 11 months. You got to keep on doing it. So let's talk about where we are right now and the latest important things you need to know. First of all, to start with COVID, nothing has really changed. In other words, all the rules that have been in place the last several months are still in place. The PED form, which you got to keep for 3 years, the posted rules of entry, no open houses, everything by appointment, buyers. There can be, unless you're in certain LA County, there can be as many buyers as you want in a buying party, as long as they're all related to each other. They're all part of the same buying party. But of course, when you go into the property, everyone wears a mask. If you're not living together, you stand 6 feet apart. You try not to touch things. The showing agent wipes down the sinks and the counters and the light switches and the doorknobs and the banisters and opens a window, weather permitting, and cleans the property like that between each showing. It's the showing agent's responsibility. None of that has changed. Still don't do door knocking in person, do things virtually by mail, things like that. As far as marketing as you can do, none of that has changed. I think the recent things to talk about real quickly are, as more and more people sort of, maybe it's stopping now, test positive for COVID. Remember, you have certain responsibilities as a realtor. Number one, if you have a showing and someone comes to your showing and they submit the PED form and everything's good, and then 3 days later they call you up and say, I was in your house 3 days ago and I just tested positive, you have to make a good faith effort to notify all of the other visitors to that property within the last 3 days, since that person who has now tested positive was in the property, or at least for the last 2 days. They basically say the infectious period starts at least 2 days before the positive test, and goes on to at least 10 or 14 days afterwards. So it's sort of like you're responsible for that type of contact tracing. Similarly, if you have in your real estate office, if you invite people into the real estate office who don't work there, like clients or agents in other offices or vendors or whatever, you don't have to get them to sign a PED form, but you do have to keep a record that they came in, so that if one of these people comes into your office, wears the mask and everything, but then they call you up a couple of days later, I just tested positive, you have to make a good faith effort to notify everyone who came into your office after that person did for the infectious period. So that hasn't changed either. There's one new thing. Here's the new thing. New law that says, talking about your office itself, it applies to all work sites, including offices. And that is, if someone at the office gets sick, someone who works in the office gets sick, it's the responsibility of the agent or the broker, the person in charge of the office, to notify everyone else who works in the office, employees and independent contractors, in writing by the end of the next business day, to tell them, hey, someone who works in the office, you don't have to identify the person, just tested positive. And I think you were in the office at the same time they were during their infectious period. Therefore, we're telling you this. We're telling you what we're doing as far as cleaning and disinfecting. And if it's an employee rather than an independent contractor, you're going to tell them what their rights are under as far as leave time, or don't have to come in, or COVID leave time, or something like that. By the way, we have a Q&A on this called California AB 685, Notification to Employees About Potential Exposure to COVID-19. It includes sort of a template in there to show you what the written notification to the people who work there should be if this ever happens to you, God forbid. Okay, so that's a brand new law that your responsibility to the people who work in your office if someone else who works in the office gets sick. Okay, so that's sort of the latest on that. We get asked a lot of questions. Seller who lives there, tenant lives there, they test positive. How long do they have to disclose to people who visit the property that they were sick? Well, 14 days is the minimum. I'm conservative. I usually say you should probably continue to disclose that for at least a month to be safe. Okay. What if you're a realtor and you test positive? How long do you have to continue to disclose, when you're out and about, that you tested positive? Well, at least 14 days, right? At least until the infectious period is over. Once again, conservatively, I think you should probably do it even a little bit longer than that just to be safe. Okay. All right. Let's talk about other things that have nothing to do with COVID. All right. New laws, new forms you should know about. There's two really important new laws, very important. One of them created a new disclosure form. It's the home fire hardening disclosure and advisory. This is the first time, believe it or not, in like 15 years that CAR has a new disclosure form. For the last many years, when people ask me, what are the mandatory disclosures if I'm selling a house? I always say, think of it as NHD plus 4. Order an NHD report and do 4 other things: the TDS, transfer disclosure, the SPQ, seller property questionnaire, the federal lead paint form, FLD, if it's pre-78 property, and the 4 disclosure booklets: environmental hazards, earthquake, home energy, and lead paint. So if you do NHD in those 4, you were good. Now it's NHD plus 5. Every time you take a listing now on residential 1 to 4, you might have to provide this new disclosure form. But the interesting thing about this form, it's not required on every deal. It's only required if the house you're selling or the 1 to 4 unit property you're selling is in a very high or high fire hazard severity zone, and it was built before 2010. So every time you take a listing now, you got to figure out if the property's in one of the zones, and is it older than 2010? If so, seller completes this form and you provide it to the buyer. Now, why is it only required on homes built before 2010? Because homes built in high fire zones after 2010 were built under the new building code that required them to be built in a fire hardened way. What does fire hardening mean? It means making improvements to your property to make it less susceptible to getting caught on fire if there's a fire. And everything built after January 1st, 2010 was built that way, dual pane windows and no wood roofs and no combustible landscaping within 5 feet of the house, etc. Whereas properties built before 2010, even though they were built in a fire zone, didn't have to be built that way. So some of them aren't, which leads to a disclosure obligation. So the first question is, okay, I have to figure out if the property I'm selling is in a very high or high fire hazard zone. How do I do that? Well, if you think about it this way, if you live in California, there's 4 possibilities. Number 1, you're not in a fire zone. That's me in Culver City. Number 2, you're in a moderate fire zone. Number 3, you're in a high fire zone. Number 4, you're in a very high fire zone. Okay, how do I figure out which one I'm in? Well, first you look at the NHD report. Remember, the NHD report has 2 fire zones on it, very high fire and wildland fire area. If neither box is checked, you're not in a fire zone. What if the very high one is checked? Well, that's one of the zones that triggers the obligation. So if it's the very high fire zone is checked, you got to do this new home fire hardening disclosure form. What if the very high zone box is not checked, but the wildland fire zone is checked on the NHD? Well, that means you're either in a moderate or a high. Well, how do I figure out which one I'm in? Because if I'm in a high one, I got to provide this form. If I'm in a moderate one, I don't. First of all, I've noticed some realtors, they just say, well, if you're in a high or moderate, we're just going to give them the form. We don't have to, but I want to give them the form anyway. But if you only want to give the form if you have to, you've got to do a little bit of further investigation to see if you're in a high or a moderate. All you got to do is ask your NHD rep. It's their responsibility to know this. And some NHD companies I've noticed have already sort of modifying their reports to make that distinction between moderate and high. By the way, another thing that confuses you sometimes is on these NHD reports, sometimes they disclose local fire zones, which is good to know, but being in a local zone doesn't trigger this new home fire hardening form unless it's also in a state zone, very high or high. Okay, so you've figured out you're in the zone and you figured out the house is older than 2010. You just pull out this form, give it to your seller, and your seller has to complete it. Because your seller has to indicate on this form, they have to basically answer 6 questions. Does your home have a wood roof? Does your home have single pane windows? Does your home have combustible landscaping within 5 feet of the home? In other words, they've got to disclose to the buyer that they've actually got features on their house that make it more susceptible to fire damage than it might be. Now, what if the buyer says, oh, I don't like your roof, you need to change the roof? Seller doesn't have to do anything. They don't have to upgrade it. Even though they're in a fire zone, they don't have to upgrade. They have to disclose to the buyer, and this might change the buyer's mind about buying the house, and that's negotiable, obviously, but they don't have to upgrade. And this form also mentions to the seller, if you have a home fire hardening final inspection report, you should give it to the buyer. And some people are asking me, what is that and who has that? Well, obviously, this is basically going to be, let's say your house was built originally before 2010, but subsequent to that, the owner of the house did some type of major remodel to the house. When the owner did that, as a prerequisite to get approval to do that, they were probably required to bring the house up to standard with the fire hardening. So they would have gotten from a building official a final inspection report indicating the property is now in compliance with home hardening requirements. So that's not going to be many people, but that's going to be some people. And the seller knows whether they have that report or not. What if the seller says, I never got a report? Then there's nothing you got to give the buyer. And if you think about it in general, right? You know, as a property owner, if you have any report you've acquired in the past, any type of like recent inspection report or contractor's report, any government report you have regarding the condition of the property, you're always going to want to give that to the buyer anyway, regardless of this law or not. In general, if you have government reports about your property in your possession, you're going to give them to the buyer no matter what. So this form doesn't really change that. Okay. All right. So that's the biggest new law, and that's the biggest new form. It's not required every deal, but it's required residential 1 to 4 in a very high or high fire zone, and that is built before 2010. Before I go on, a couple questions. Deanna had a multiple listing agents not allowing a family of 4 to viewing a home. They were wrong unless they were in LA County. Lisa, when you're asking about disclosing, I think you're getting back to the thing about disclosing to other people who work in the office that someone in the office tested positive. It's actually by the end of the next day. When did this new law start? I assume you mean the home hardening law. That was January 1st of this year. So any listing you took this year, this started. Teresa, yeah, I said no door knocking. What about leaving a bag with a newsletter or a flyer? That is the big gray area. You talk to some people at the DRE, they say they shouldn't do that. Some people at the DRE say that's okay. The guidance itself doesn't address that specifically, although the guidance does specifically say you can't leave flyers at a listed property. So some people say, well, if you can't leave flyers at a listed property, why should you be able to leave flyers at a not listed property? But the rule doesn't specify it exactly. And then the governor's original stay-at-home order, which is still in effect, says the only things you should be doing outside your house are essential activities. And then they list essential activities, and they don't list dropping off flyers. Put that all together, what does that mean? Which means it's not clear. I always give conservative advice. So I say it's probably not a good idea dropping off flyers. I cannot say it's specifically prohibited though. Deanna, yeah, you're not even supposed to leave business cards after a showing, believe it or not. And as Vicky says, of course, use the mail, use email, use anything like that. You can certainly mail things, physically mail things, absolutely, for sure. All right. Next most important law you need to know about is, Terry, as I said, it's a gray area whether it's legal or not to leave flyers. I cannot say 100% sure. My advice is don't do it. And you listen to whatever your broker or manager says as to what you should do. Okay. Second really important new law is the extension of the eviction moratorium from February 1st to July 1st. What does this mean? It means for another 5 months, landlords cannot evict tenants in residential properties for not paying their rent if the reason they didn't pay was COVID. If someone doesn't pay the rent and they don't have a COVID reason, you can evict them right now. If they have a COVID reason, you can't evict them until July. They still have to pay 25% of the rent. What if they have a COVID reason, but they don't pay 25%? You can't even evict them, even though they don't pay the 25%, you still can't evict them until July. What if they do pay the 25%? Can I evict them for not paying the extra 75%? No. All you can do is sue them for the money. You cannot evict them. Now, come July, they owe the entire month's rent, whether they have COVID or not, and then you can evict them. But if they pay 25% until July, and starting in July, they pay the full amount, you can't evict them for the 75% that they owe you. You can only sue them. And you can't sue them until July. In August, you can sue them in small claims for however much they owe you, even if it's more than $10,000. The question is, how do you know that the reason they're not paying is COVID or not? the only way to find out is to give them an eviction notice, a notice to pay or quit. But of course, you cannot use the standard 3-day notice to pay rent or quit for the next 5 months. You got to use the 15-day COVID pay rent or quit. You submit that form. If they reply within 15 days with the declaration of COVID financial distress, they've signed that under penalty of perjury, and you have to accept their word for it that they have a COVID reason. If it turns out they're lying, they can go to jail. It's a criminal offense, but you have to accept it at this point. Okay. What if the lease is up and you just want them to leave? You can't do that, but I'll get to that in a second. Okay. So first of all, the basic rule, you understand, right? If they're not paying rent and they sign the COVID declaration, you cannot evict them until July, even if they pay the 25%. And if they pay the 25%, you can never evict them for that, not paying that rent. Well, what if they're doing something else bad? What if they're not allowing me to show? You can evict them, unless you're in LA County, where they don't have to let you show. What if they have tenants, subtenants they shouldn't have? Can I evict them for that? Yes, unless you're in LA County. What if they have pets they shouldn't have? Can I evict them right now? Yes, unless you're in LA County. What if they're engaging in criminal activity on the property or they're damaging the property? You can evict them everywhere, even LA, right now, okay? But once again, you don't give them the normal 3-day notice to cure breach of lease covenant. You give them the COVID 3-day notice to breach, okay? All right. Now let's get to the stuff you really want to know. Can I evict a tenant just because I want to sell the house? In other words, they're paying me rent. That's not an issue. Or they're not violating anything else, but I just want to get them out of there. Can I get them out of there for no fault? Well, normally in a single family home, you don't need a reason. Normally in a duplex, you don't need a reason. Normally if it's a building newer than 15 years, you don't need a reason. You don't need just cause. From now until July, though, you need just cause to evict any tenant for no fault, even if it's a single family or duplex or new home or new apartment building. What are the legitimate reasons I can evict a tenant now for just cause? There are 4. Number 1, I need to do a major remodel of the property, but that only works if the remodel is necessary for health and safety reasons. If you just want to remodel to get it ready for sale, you cannot kick out the tenant. Number 2, and by the way, LA County, there are no fault evictions in LA County until at least the end of March. And if you're in LA City, until at least the end of June. But assuming it's not LA City or County, you have 4 reasons right now you can evict. Number 1, necessary remodel for health and safety reasons. Number 2, you want to move in yourself. You, parent, grandparent, child, grandchild, or spouse. Hey, that's easier than divorce, right? Just say to your spouse, I'm sorry, honey, you got to move into the rental so we can kick the tenant out. Just kidding, right? Just kidding. Okay. Anyway, 3rd legitimate reason to evict a tenant, not in LA County, is you want to take the property off the rental market. By the way, I'm assuming that none of these properties, the tenant is on a lease. If the tenant's on a lease, you can't do anything till the lease is over, assuming it's month to month. Okay, so can I take it off the rental market because I'm selling it? No, if you take it off the rental market, you got to take it off the rental market for at least 2 years. If you want to put it back on the rental market, you got to rent back to the same tenant who was there before at the same rent. So that's not really going to work, right? If you want to evict the tenant because you're taking it off the rental market and then you sell it to a buyer. Maybe the buyer's okay with that, but that buyer has to understand that they can't rent it out either for 2 years. Fortunately, there's a 4th good reason to evict a tenant so you can sell the house, and that is if you have a single family home for sale, as soon as you get a buyer who commits on the purchase contract to live in the house, and that offer is accepted by the seller, at that point, you can evict the tenant. Even if they have COVID, you can evict them because you're selling the house and you're in contract with a buyer who says they're going to live there. So you got to wait till you have the accepted offer. Okay? And this doesn't work right now in LA County, at least till the end of March, or LA City till at least the end of June. And those might get extended anyway. Okay. So, and you're not going to give them the normal 60-day notice to terminate tenancy. You got to give them the COVID 60-day notice. 60-day notice if they've been there more than a year, 30-day notice if they've been there less than a year. But you can do that. Okay. What about the tenant who says, I don't want to allow you to show it? I'm worried about COVID. LA County, they can say that. Anywhere else, they can't. They have to allow you to show it, or it's grounds to evict. But what if the tenant is like 80 years old and has underlying conditions that makes them especially vulnerable to COVID? Well, in that case, they're probably qualified as having a disability. And when a tenant has a disability, you have to reasonably accommodate their disability. What does that mean? Not clear. Maybe you got to put them up in a hotel while you're showing it or something like that. You try to work with them. You can't just outright force them to allow it if they have a disability. Okay. All right. Going back to the questions, Tari asked, yeah, the tenant doesn't have to prove they have a COVID issue. You have to take their word for it. You can't just give notice unless you have one of those 4 reasons. I gave you the reason, and right, Wendy, exactly. That's what I just said. I know you put it in there before I said it. Does the tenant have to cooperate with inspectors and appraisers? Yes, they gotta cooperate with everybody. But these people have to follow the protocols, right? The PED form and the wear the mask and do all that. But the tenant does have to cooperate unless you're in LA County or unless they arguably have some type of disability. And of course, cash for keys is still legal. In other words, you can bribe the tenant to leave. Bribe the tenant to leave. Melissa, yeah, I'll try to put the 4 reasons in chat. I would recommend you just get a copy of our Q&A called SB 91, the Tenant Relief Act, which explains all this stuff. But I'll try to put it in chat later. Kim Howard, how long? Yeah, Mark, yeah, someone asked me, the new buyer has to be an owner occupant. They have to commit on the offer that they plan to live there if you want to be able to evict the tenant. Of course, there's nothing saying they can't move in and leave 3 months later. Although if the tenant finds out, the tenant may come back and sue and say they didn't act in good faith, blah, blah, blah. Who knows? Who knows? Kim Howard, very good question. How long can I use a PED? As Vicky already answered, you need a PED for every showing. Don't use an old one. You need a new one. Because remember, it has health information on there that can change on a daily basis. So you know, I know it's a pain, but you got to do for the time being. A lot of what you do is a real pain right now, but you just got to do it. Okay. All right. By the way, there's good news coming for landlords. Brenda, yeah, if their lease is up, it doesn't matter. You can't kick them out unless you have one of the just cause reasons I said. Necessary remodel, owner move in, taking property off the rental market for 2 years, or you have a buyer who's in contract and the buyer says they're going to live there. Okay. Owner move in, a remodel that's necessary. You're taking it off the rental market for at least 2 years, or the best one is you have a buyer. None of these work in LA right now. Thank you, Vicky, for putting that in there. Okay. Good news. There is money coming to California to compensate landlords for the back rent that they're owed. There's money coming now, and hopefully this new bill that they're talking about in Washington, the new stimulus bill will get passed, and more money will be coming to California, billions of dollars. The first set of $2.5 billion is going to be administered by HCD, Department of Housing and Community Development. They're required to get the program up and running by March 15th. They haven't done it yet. Hopefully it'll be on time. Once that's up and running, if you are a residential landlord and you have a tenant who owes you back rent that they didn't pay because of COVID, any back rent they owe anywhere back to last March to up until now, up until July, if they owe you money for COVID, you'll actually be able to apply through HCD for the government to give you money. Sounds too good to be true, doesn't it? Well, it's, of course, there's some strings attached. One of them is landlords are only going to be eligible for this first round of money if the income of the tenants who aren't paying the rent is less than 80% of the area median income, which we're going to put on our website, I think today, how you can calculate. It's county by county. In other words, you'll look up on that, what is the median income in my county, and then multiply that by 80%. If your tenants are making more money than that, even with COVID, you won't be eligible for this first round of landlord assistance. If your tenant is making less than 80% of your area median income, you will be eligible to apply for the money. So let's say the tenant owes you $20,000 in back COVID rent. Obviously, you can sue them in July, but you don't want to wait till then. You don't think they're going to have any money anyway. You want to get the government money. So you apply. Like I said, we don't know exactly how it's going to work yet. HCD hasn't set it up yet. They're setting it up. But you'll apply. And let's say you say to HCD, I got a tenant, they owe me $20,000 back rent. And they're within 80, and their income 80% of the, and obviously the tenants are going to work with you on this because they want you to get this money so that you don't have a judgment against them for the back rent. They want the money. They want you to get. Okay, so you're going to submit your application to HCD, say the tenant owes me $20,000, give me the money. Well, you know what? Here's the strings that are attached to that. If you're eligible for the money, the government's going to say, okay, they owe you 20, we'll give you 16. What about the other 4? You have to forgive that. If you want the government money, they're going to give you 80% and you have to forgive the remaining 20%. What if you don't want to forgive it? Then you're not going to get the money. It's that simple. And if you're not willing to do that, you're thinking you're going to sue the tenant for all the money, then the tenant can separately apply to get 25%. So they can apply and then the government will give them 25%. So at least they have the 25% that they have to pay. But if the landlord's going to want this free government money, they're going to have to waive 20% of what they are owed. So that's a decision landlords are going to have to make once this is set up. Now, I'm hopeful, maybe, that if this new stimulus bill gets passed in Washington, that's going to result in billions more money coming to California, that landlords will be eligible. The ones that didn't get it the first round, hopefully get it the second round. Who knows? Plus, California just passed a law making more COVID money available, not specifically for landlords, but more money available. We'll have that on the website. I haven't even looked at it yet, but not specifically for landlords. Okay, so that's the latest on rentals. Paul, ask your tax advisor about your ability to write off that debt, that 20% that you don't get. Yeah, talk to your tax advisor. Okay, hopefully, yes, our economy will get stimulated, we hope. Okay, so those are the big 2 laws. The third biggest law is Prop 19. So we've talked about COVID and the new notice you have to give to employees and independent contractors if someone gets sick. We've talked about the HHDA, that new law, the new disclosure. We talked about the tenant stuff. The next most important one is Prop 19. Prop 19 takes effect April 1st, but it's not clear. You might be able to take advantage of it before that. Here, let me give you the setup. Under current law, before Prop 19, we had Prop 60 and Prop 90. You know what that law says, if you're over 55 or disabled, you can sell your existing house and move anywhere in LA County, Riverside County, San Bernardino County, Ventura, Orange, or San Diego, not Imperial, but anywhere else in Southern California. And you can transfer your low property tax base on your old house to the new house. You can do this one time as long as the new house costs less to buy than the sale price of the old house. That's current law, existing law. Prop 19 makes that better. Prop 19 says you can transfer the property tax basis of your existing house, and you don't just have to stay in Southern California. You can move anywhere in California. Number two, you can do it 3 times, not once. Even if you've already done it once under Prop 6, you can do it 3 more times. Number 3, you can do this not just if you're over 55 or disabled, but also if you've been a victim of a wildfire. And the best thing about it, I think, is you can sell your existing house, buy a more expensive new house, and still transfer the low property tax base on the first house to the second one. But there's a slight adjustment if you do that. Let me give you an example. Let's say you bought your house a long time ago for $100,000. So you've been paying property tax based on $100,000. Now your house is worth $700,000, but you're over 55, you want to move. And the house you want to move to is actually more expensive than the old house. It's actually costs $800,000. Under Prop 60, you couldn't transfer your property tax. Under Prop 19, yes, you can. What's your property tax basis going to be when you buy the new $700,000? It's going to be your current 100 plus 100, the difference between the purchase price of the new one and the sale price of the old one, which is 100. So your property tax basis on the new house is going to be 200,000, which is a lot better than it being 700,000 if there were no Prop 19. So do you have to buy a new house right away? No, you got 2 years. But you can't transfer the property tax basis on the low one you were paying on your old house until you buy a new house. In fact, you can buy the new house first, but you still can't transfer the low property tax basis on the old house until you actually sell that one. Okay. And you can do it 3 times. You got to wait 2 years, but then you can keep doing it, right? So yeah, there has to be 2 years, no more than 2 years between transactions. Now, Vicky's asking the great question, when does this all go into effect? It flipped. No, it doesn't apply to out of state. Sorry. Can't leave California. But the effective date is April 1st. Does that mean I can't do either end of this purchase until April 1st? Or can I sell now and then transfer, make the transfer of the property tax basis after April 1st? We think that's the answer. But the assessors say we can't, we need legislation from the state making that clear. So if any of you are in a situation where you or your client already sold and closed a house, and now you want to buy a more expensive one and still transfer your property tax base, or you want to move outside of Southern California, we're not sure you can do it because you sold the old one prior to April 1st. We think you can, and we're waiting day by day to get an answer. We're pressing the legislature, emergency legislation, to make that clear. But right now, you can't guarantee to your clients that you can close either one of them before April 1st and transfer the property tax base after April 1st. Remember, if the new house is cheaper than the old house, you can do it right now, but you got to stay within the counties I mentioned. Someone asked, Mo asked, what about Imperial County? No, Prop 19 applies to everywhere. It's just Imperial County, the Prop 60, Prop 90 doesn't apply. But Prop 19 is absolutely everywhere. Yes. Okay, let me get some questions. The formula again for calculating the new tax. The property tax you're going to pay on the replacement property is the same exact property tax base you had on the original property, plus the difference in sales price on the purchase of the new one compared to the sale of the old one, if it's a higher price. So if you're paying more for the new one than you sell the old one for, you have to add that difference to the original property tax base. If the new one is cheaper than the old one, you're downsizing, you transfer the property tax directly to the new house, okay? Yes, Krista, there's a negative aspect of Prop 19, and that is, but it's not as bad as you think. Well, let me put it this way. Normally, as you know, when you transfer ownership of a property from one person to another, it gets reassessed. But for many years, there's been an exception to that for intergenerational transfers. So up until recently, if you transfer your primary residence and an additional $1 million worth of real estate to your child or grandchild, that transfer does not trigger reassessment. Well, the legislature was targeting that to take that away. They're saying, you know, we're going to take that away, raise some money by taking away the intergenerational property tax exemption. Well, before they got a chance to take it away from everybody, Prop 19 says you can still transfer your primary residence to your child or grandchild without reassessment, but they have to use it as their primary residence. Whereas before, they didn't have to use it as their primary residence. That sounds bad, and it is bad, but we firmly believe that this was going to go away anyway. So at least that is preserved. And you can no longer transfer $1 million worth of other real estate to your kid without triggering reassessment. Okay, so the intergenerational transfer exemption from property tax reassessment has been changed for the worst, but it's pretty clear it was going to happen anyway. Okay, all right. Tracy, what if the client bought the more expensive one in January 2021 and will sell the lower one after April 1st? Tracy, that's the question we're all waiting for the answer. We hope the answer will be yes, come April 1st, you can transfer it. And we're pretty sure that's going to be the answer. That seems to be, we're not hearing a whole lot of objection to that, but until it's official, people can't do it, okay? But we're thinking that's gonna work. What if the sellers are buying their new home with their daughter on title? Well, that's still, if we're getting back to the portability of the property tax, yeah, they can still transfer. It's still their property. Just because they're adding their daughter doesn't mean it's not their property. They can still transfer the property tax. Okay. Janie, what if you have two joint tenants owning property and one passes away? So the surviving joint tenant acquires the property. You know, unfortunately, that triggers reassessment under old law and new law. That always triggers reassessment. Okay. All right. Let's keep going. We're almost done here, but other new laws you need to know about. There's maybe 3 more. Vicki, I think you're talking about the intergenerational transfer that took effect February 16th. So that has happened. Next law you should know about, interesting. Listen to this. Let's say you live in a condo that's part of an HOA, or maybe you live in a single family detached house that's part of an HOA. Can an HOA prohibit you from renting out your property? Prior to this year, the answer was yes. The answer now is no. An HOA cannot put unreasonable restrictions on your ability to rent out your property. And that's what is considered reasonable. It's defined as HOAs have to allow at least 25% of the people who live there to rent out their units. And if you rent out your garage or converted garage or your granny flat in the backyard, that doesn't count as renting out your property. So 25% have the right to rent out their whole property. Okay. Well, can the HOAs still say things like, well, you have to live there 2 years before you can rent it out? Well, is that reasonable? I don't think that's reasonable, but a judge is going to have to decide, because remember, they can still do reasonable restrictions. Can they say you can only rent it out to family members? I don't think that's reasonable. We'll see what the judge says. Can they limit you to the age of the people you're going to rent it to? Only if it's a senior citizen complex can they put restrictions on the age of the people. Lonnie, great questions. HOAs can still prohibit short-term rentals. They can still prohibit Airbnb-ing the property, okay? This law took effect January 1st, okay? Back to questions, Francesca. Once again, it used to be before February 16th, you could transfer primary residence plus $1 million worth of other real estate to your kids without triggering reassessment. Now it's only primary residence that can be transferred, not additional property. And they have to use it as a primary residence themselves. Brenda, where can we find that a tenant must show the property? It's in the Q&A, or call the legal hotline, I think, and they'll be able to send you something to confirm that, if you don't mind. Okay, so that's pretty good news about HOAs can't restrict your ability to rent. Paul, I'm not sure what your question means. What if it's in the lease? If what's in the lease? Maybe explain to me what you mean by what's in the lease. You mean the restriction on renting or something like that? Because I'm talking about HOA's ability to tell people that they can't rent their property. You're right, Paul, you're right. Our lease form does say the tenant needs to show the property. So, right, that's a good answer to Brenda's question. Thank you, Paul. Because I'm saying the law says that, civil code something, but you're right, it's actually in the lease. But guess what? If you're in LA County, even though your lease says the tenant has to allow you to show the property, the LA County and the LA City law supersedes your lease, and the tenant doesn't have to allow you to show. We think hopefully by the end of March, if you're not in LA City, you might be able to. If you're in LA City, who knows how long it's going to be, okay? As far as this HOA stuff, we have a handout on our website called 2021 New Laws, and it lists all of these new laws, and we can just go to the CAR.org, and in the search, put in 2021 New Laws, and you can get all of this information on all these new laws that I'm talking about. Let me talk about another new law. This one's going to blow your mind a little bit. Foreclosures. First, before I get to that, here's good news on foreclosures. There's a foreclosure moratorium on all government-backed loans till at least June. FHA, VA, etc. More good news is, even if it's not a federally government loan, all California borrowers who are having trouble paying their mortgage for a COVID reason, they have until June 30th to apply for relief. The relief is called forbearance. What that means is, if you can't pay your mortgage and you have a COVID reason you can't pay, and maybe the COVID reason is you got a tenant who's not paying you, the lender has to allow you to sort of not make the payment now and attach it to the end of the mortgage in the future. They have to basically allow you to do that in most cases, and they have to allow you to do that for at least 12 months of mortgage payments. And if you've already done this and you're almost reaching the 12-month deadline, and you still have a legitimate COVID reason why you can't pay your mortgage, they're supposed to give you an additional 6 months. So we'll see what's going with that. Jack, yeah, short-term means 30 days or less, right? So they can prohibit short-term rentals of less than 30 days. Okay. Thank you, Vicky, for the link to what I was just talking about. Okay, almost done here. Back to the new law I was going to talk about. Let's say you got a house in foreclosure. By the way, when it comes to commercial, we're back to normal. Commercial tenancies, same as it was pre-COVID. Commercial foreclosures, same as it was pre-COVID. Let's say you got a residential property in foreclosure and there's a sale date, and you show up at the auction and you bid on the property and you win. Normally, before this year, that means that's your property. Not anymore. Not so fast. If you foreclose on a tenant-occupied property, and you, the person who forecloses, are an investor who doesn't plan to live there. If you're going to live there, it's yours. But if you're not going to live there and you foreclosed on a tenant property, the tenant has 15 days to notify the trustee that they want to buy it instead for the same price that you bought it for. And if they submit that within 15 days, they got 30 days after that to actually come up with the money and close the deal. And if they can do that within a total of 45 days from the auction, they get it. You don't get it anymore. You thought it was yours. It's not yours because there was a tenant there and a tenant matched your bid. But let's say there's no tenant there. Is it mine? Not so fast. If you foreclose on a residential property and you, as an investor, you don't plan to live there, anybody in California who wants to live there can submit a bid to buy it within 15 days after the auction. They've got to swear under an affidavit that they're going to live there, and they have to bid more than the winning bid at the auction. So you're thinking, why didn't they just go to the original auction? Why would they wait till after the auction to submit a new bid for more money? But be that as it may, if that's what they do, they submit this bid within 15 days, and if there's more than one bid, they're the highest bid. If they can close the deal within 45 days, they get the property. So in other words, the person who originally went to the auction and won the bid, they don't know for 45 days whether it's their property or not, unless they plan on living there. If they plan on living there, it's theirs right away. So that's an interesting one, isn't it? All right. Let me tell you one more law that's good news for everybody. And that is, there is, actually, I'm going to take the full 5 minutes to tell you about a couple things. Everybody, I don't care where you live, your homestead protection has gone up. What does that mean? If you own a house, your own house, you live in a house, you are protected from a creditor foreclosing on your property if you owe them money. The protection is, even if they sue you and get a judgment, they can't foreclose unless they have enough money in the judgment to pay your homestead and pay off any secured liens you have against the property. So let's take me, for example. And by the way, up until this year, your homestead depended on your status. If you were single, your homestead was 75. If you were head of a household of at least 2 people, 100,000. If you were over 65 or over 55 and disabled, it was 175. So let's say me last year, head of a household, homestead of 100,000. Let's say I owe my lender 150 on my mortgage. That's a total of 250. Someone sued me for 240,000, got a judgment. They couldn't touch my house because they don't have enough money to pay me my 100 and my bank my 150. On the other hand, if they got a judgment against me of 500 last year, they could have foreclosed on my house, give me the 100, pay off my lender and keep the rest because my homestead was 100. You know what my homestead is today? 600. Everyone in California, your homestead amount, it doesn't matter anymore if you're single or over 65 or whatever. Everybody who owns their own house, your homestead now is a minimum of 300,000 or the median sales price of a single family home in your county in the prior year. LA County, the median sales price of a single family home last year was over 600. So it's capped at 600. So everyone who owns a house in LA County, you've all got a 600,000 homestead. What if I live in Riverside, San Bernardino, Orange County? I'm pretty sure Orange County is also over 600. I'm not sure about Riverside, San Bernardino, but maybe it is. Whatever it is, that's your homestead. There's some counties, believe it or not, where the median sales price last year was under 300. People in those counties, their homestead is 300. Everybody else, it's either the median sales price of a single family home last year or 600, whichever is lower. Okay. Terry, what if you own more than one home? You can only have one principal residence. So it's that one, right? Everyone has one principal residence. Do I have to record a declaration of homestead to get this protection? No, it's automatic. But you should record a declaration of homestead because by recording it, not only are you protected from a foreclosure, but you can actually voluntarily sell your house and the judgment won't attach to the proceeds as long as you invest the proceeds in a new house within 6 months. So it's in everybody's interest to record at the county recorder's office a declaration of homestead. But even if you don't do that, you're protected from a foreclosure anyway. Okay, so that's good. So that's about it for the new laws you really need to know. Let me wrap up. Are there any form changes I should know about? Well, I forget what I even tell people anymore. I think I didn't tell you this. Getting back to that Tenant Relief Act, there's a new form you have to do. It's very important. I'm sorry, I forgot. If you're a California landlord on a residential property and your tenant owes you COVID back rent, there's a new disclosure form you must give to the tenant by the end of February. It's called the NTRA 2. Stands for Notice of Tenant Relief Act 2. The reason it's got a 2 is because there was a similar form a year ago that came out. Every California landlord who has a residential landlord who has a tenant who owes them back rent that they didn't pay because of COVID, you got to deliver this form to the tenant by the end of the month. What if I don't do it? You may have trouble evicting them in July, even though they didn't pay the 25%. So please do that by the end of the month. NTRA 2 if you are a landlord. By the way, if I'm a realtor representing a client who actually has a tenant, is it my legal obligation to tell them this? No, not unless you're their property manager. What I would do is if I had any clients who were landlords, I would say, there've been some changes to the law. You should probably talk to your own California real estate attorney who will tell you what you need to do. You shouldn't actually be the expert. Unless you yourself are getting paid to manage the property, then it's your responsibility. Okay. All right. So the NTRA 2 mandatory new form. I also told you about the fire hardening disclosure form, mandatory new form if you're selling a house in a very high or high fire zone built before 2010. Any other new forms? Well, not really new forms, but I did mention someone in the office gets sick. There's a written notice you have to give to everybody else who works there. All right. Any other new forms? Just one. Came out in October. You're familiar with it by now, the Fair Housing and Discrimination Advisory. As you know, it's attached to your listing form, so please get your seller to sign it. It's attached to your purchase contract. Please get your buyers to sign it. It's attached to your rental form. So if you're a property manager or you have a lease listing, make your landlord sign it. If you're representing a tenant, make them sign it. This, by signing the form, they can't come back to you and say, hey, you didn't explain to me all these fair housing rules I have to follow. And the answer is, yeah, I did. Remember that form I gave you and you signed it? You should have read it to tell you what not to do, right? By the way, the one thing it mentions on that form, Vicky, you read my mind. It discourages, it talks about the risks of, as a buyer, submitting a letter to the seller. In other words, some buyers, instead of just submitting an offer, they submit a letter, like a love letter with the offer. And sometimes they have photos. They're basically saying to the seller, pick me. Isn't my family beautiful? My husband and my 3 kids will thoroughly enjoy this property. We'll take care of it just as well as you did. It's perfect for us. My husband can open his dental office here. It's great. What's the problem with that? The problem is sellers are not allowed to base their decision on who to sell to, or landlords can't base their decision on who to rent to based on personal characteristics of the seller, based on whether they're married or not, based on whether they have kids or not, based on what they do for a living, based on what their color of their skin is, country of birth, age, gender, disability. So when the buyers write these letters, especially when they include photos, they're telling the seller all these personal characteristics. If I'm the seller, I don't want to know this. Because if I know this, I can be accused later of bias. Someone may say, why didn't you sell to me? Why'd you sell to them? Oh, I get it. They don't have kids and we have kids. You don't like families with children. Or they're this skin color and I'm that skin color. You must not like people this skin color. Or they're a dentist. I'm a dentist. You must not like dentists or something. You see what I'm saying? As a seller, from a risk management perspective, I'd rather not know these things so no one can accuse me of bias. Does this mean these letters are illegal? Absolutely not. What this form says is have this discussion with your seller for the listing agent. It points out the risk. The seller might say, hey, good point. I agree. Let's not get any letters. So you can put in the MLS, please don't submit letters with your offer. Maybe the seller says, I understand, but I'm willing to run the risk. I want these letters. In which case, when the letters come in, you give them to the seller. It's the seller's call. You know what I'm saying? Basically. Okay. All right. Let me think. I'll finish. Let's see if there are any other questions. Donna, very good question. This NTRA 2 form, I got a tenant household. There's more than one tenant. Maybe I'm not sure what you're asking, to be honest. Let's put it this way. You only have to give this NTRA form to tenants who are not paying full rent because of COVID. You forget about multiple tenants. If the tenant household is paying full rent, you don't have to give this form. It's only if they're not paying full rent and the reason they're not paying is COVID that you have to give them this form. And one more question I got. Yeah, the 600,000 I mentioned is separate from liens. I don't care how many liens you have against this property. You might not have 0 actual equity. You still have a $600,000 homestead. It's nothing to do with what we normally call equity. It's just you got that protection from foreclosure automatically. Okay? All right. Oh, Janie, great question. You are allowed to discriminate against investors. So you are allowed to ask if the buyer is going to live there, and you can definitely discriminate against the investor in favor of the person who wants to live there. Great question. What about open house? We don't know when. Obviously, we're moving in that direction. The trajectory of the virus is definitely going down. Things are going to open up. And the big thing that everyone wants to open up is, I want to be able to do traditional open houses where people don't have to make an appointment. Right now, you cannot do that. And I don't know when that's going to change. That's the best I can tell you. Yes, Christy, unfortunately, some people are violating the rules. All I can tell you is report them to the Department of Real Estate. And the DRE, basically, I've experienced sometimes the DRE is taking action. Open houses in the traditional sense are not legal. You can also report them to the Department of Public Health. People can get sanctioned for this. People can get fined for this. And if, God forbid, someone gets sick and it can be traced out of the fact that they had an open house, they're going to have a terrible lawsuit on their hands. So it's strongly advised that you don't do this. You don't have traditional open houses. That's all I can say. Yeah, we get that question all the time. And it's just, they shouldn't be doing it. It's clearly a violation to have traditional open houses. You know what? All I can say to realtors, you've survived this long without open houses. Try to survive a few more months, and hopefully we'll be back to normal in the relatively near future, is all I can say. All right.
Gov, I bet you have another Zoom call to jump onto this afternoon.
I do, but fortunately I get a short break for lunch. So
Awesome.
I'm going to say goodbye to everybody and go eat lunch.
Thank you so much for everything. Note to self, record a declaration of homestead, and there is a new form. The RPA is coming out in December with 16 pages. So more to come. Gov,
Well,
thanks, my
hopefully I'll be
friend.
seeing all of you then. I'm going to be teaching a lot of classes on the new form. So we'll see you
Yes,
then.
you'll be seeing us.
Okay,
Thanks,
I'm going to
Gov,
leave.
again. Appreciate it, my
Bye-bye.
friend.